I'll just quickly introduce Zach Passmore. He's one of our enforcement attorneys here at the South Carolina Department of Consumer Affairs. We're so happy he's here to talk about the Homeowners Association and all of the laws that apply to them today. So Zach, I'll let you do the honors of officially introducing yourself.
Okay, thank you, Bailey. Appreciate it. Good morning, everyone. My name is Zach Passmore, and as Bailey said, I am an enforcement attorney here at the Department of Consumer Affairs. I've been here for just over 4 years now, working in the legal division, and I'm here to talk today, kind of give a broad overview about the various HOA laws that we have here in South Carolina. Before I start getting into the subject that we're here for today, I have to throw up the disclaimer here that this is not meant to serve as any kind of legal advice or substitution for reading the laws that I'm going to talk about today. If you have any specific HOA issues, I would recommend on the outset that it's likely something that I'm not going to be able to answer, and it's probably something that you're going to have to discuss possibly with legal counsel. But I am here today to kind of discuss broadly the statutes that cover homeowners associations here in South Carolina. So with that out of the way, let's kind of get into the meat of today's presentation and discuss the South Carolina laws that may or may not apply to a homeowners association. So basically there are, as far as what a homeowner or a homeowner association can or cannot do, are outlined in basically 2 buckets. The first one being applicable state laws. In this case, that would be 3 statutes. There's the South Carolina Nonprofit Corporation Act. There is the South Carolina Homeowners Association Act. And there's also the South Carolina Horizontal Property Association Act. One or a couple of these laws may apply to a particular HOA, determined by how they are set up. The other bucket of information that tells an HOA what they can and cannot do, well, that is the HOA governing documents that the HOA makes themselves. That is further broken up by their governing documents, declaration, master deeds, and bylaws that they may have to file. These kind of documents generally cover the operation of the HOA itself, how voting goes, things of that nature. And then the second bit of documents are the rules and regulations, the covenants, conditions, and restrictions, also known as CC&Rs. Those generally cover the homeowner side, homeowner's responsibilities, things they can and can't do, their rights and obligations. So today I'm kind of going to go through the state laws because you know the HOA governing documents, they vary by HOA, so I can't really touch on what any of them have other than the general provisions that are provided by that first bucket, the applicable state laws. And I'm going to start, I'm going to go in the order from generally the least restrictive or least detailed regarding HOA itself into the most restrictive or most detailed. So under that frame of reference, we're going to start with the South Carolina Homeowners Association Act. This is the broadest one with regard to outlining the kind of things that a homeowners association must set up. There's also some confusion that we hear about regarding the Homeowners Association Act, and that's just by way of how an act becomes law. So starting in the early 2000s, there have been several HOA bills that have been introduced at various times in the legislature, and they take all sorts of different forms. Some are very similar to each other. Some of them deal solely with governing documents, and some also deal with, you know, just other aspects of homeowner associations. But with regards to the Homeowners Association Act, only one has passed, and that is the one that I'm going to discuss today. The reason why I make that point is because this act, through the legislative process, was heavily amended. So if anyone, if a consumer is, for instance, doing an internet search, looking for provisions of the Homeowners Association Act, A lot of times what they will find, what some of the first hits will be bills, proposed legislation that was never adopted and made law. So just kind of wanted to bring that up. I know myself, when I've tried to search for certain provisions of this act, I often get portions of bills that are not actual enforceable law. So it is important to note that I am covering the part that is enforceable. That is the law that's been adopted by the legislature. So as far as this act, it applies to communities and horizontal property regimes requiring homeowners to pay assessments. This does not include timeshares. There is a filing requirement under this act. Any governing documents, being the HOA declaration, master deeds, and bylaws, if they existed before the time that this act became effective, which was May 17th, 2018, they must have been recorded in the county where the association is located by January 10th, 2019 to be enforceable. And after that point, if any governing documents are created or amended after this time, rules and regulations, they must also be filed in the county by January 10th of each year following their adoption or amendment. A good question is, where are these documents required to be filed? That depends on the county that the HOA is located in. It could be one of possibly 3 different places. Some counties require that it's filed with the clerk of court. Some require that it's filed to with the Register of Deeds, or possibly there are some counties it's called the Register of Mean Conveyance. But depending on which county you're in, these documents, the governing documents, have to be recorded by January 10th, and if they're amended or rules and regulations are adopted, they must be filed by January 10th of the following year in order to remain in force. So under this act, there are some provisions for what kind of documents a homeowner has access to. These include the rules, regulations, and amendments. HOAs must make rules, regulations, and their amendments available to members upon request, unless the HOA takes the steps to post them in a conspicuous place in a common area in the community, or make them available on a web page maintained by the HOA where a member is able to download them. There are other means that they can make these documents available to members. Those would be decided upon by the HOA themselves. For instance, if they have in their bylaws that they can email them, they can also do that as well. Some other documents that homeowners have access to are budget and membership lists. All HOAs are subject to certain access to documents requirements in the next act that I'm going to talk about, the South Carolina Nonprofit Corporation Act. Some of those provisions apply to HOAs in general. So being that access to budget and membership lists for members to inspect and copy the association's budget and their membership lists. So if a homeowner is in a situation where you have requested these kind of documents, the HOA has not made them available to you, under this act, the enforcement mechanism for homeowners is court. So if you are generally in a situation like this, court is the avenue to enforce your request for documents. And I would, I'll talk about this later, but I would recommend you speak to a private attorney or file a complaint with our department so that we can help through the mediation services that I've discussed. There is a meeting notice requirement on HOAs under this act. Associations, other than nonprofit corporations, and that is an important distinction that will make sense later in this presentation. But associations other than nonprofits must provide homeowners notice 48 hours in advance of the meeting in which a decision to raise the annual budget is made. It's important to note that this notice can be made through posting, kind of the same way that rules and regulations are are required to be posted in a common area in the community on the HOA's website, by email, or by any other method described in the bylaws. It's important to note here that this is the only type of meeting that the Act explicitly says advance notice must be given, and that is for the decision to raise the annual budget. There could be other meetings that the HOA may have that may not have this notice requirement. And as I said, it's also important to note this applies to associations that are not nonprofit corporations. Nonprofit HOAs or nonprofit corporations have their own notice requirements that I will talk about in a minute. So under the South Carolina Homeowners Association Act, there's also a disclosure requirement for home buyers. A seller must let a purchaser know if their property is part of a homeowners association through what's known as a South Carolina Residential Property Disclosure Statement. This is a document that is created by the Department of Labor Licensing and Regulation, LLR. They regulate various types of business in this state, including real estate agents. And one of the parts of the disclosure statement discloses whether or not a property is subject to an HOA. But just as a tip, our department recommends that consumers or potential home buyers also attempt to gather more information outside of the residential property disclosure statement. If you are thinking about purchasing a home and you want to know if it's in an HOA, what we would recommend is that you get a copy of the governing documents as well. The seller is not required to provide those to you by law. However, you should be able to get them through, like I said, that responsible office where those kind of documents are recorded in your particular county. You should be able to get the governing documents there and request a copy. We also recommend requesting if any minutes of the last 12 months of HOA meetings and getting any copies of any newsletters that were released during that time to gauge what's going on with an HOA. Also, if you can, make sure to get a statement in writing from the HOA that the home you are buying is not already in violation of any of the association rules and regulations. And lastly, if you can, if you're able to, try to attend an association meeting and see how well their meetings are run. That could be kind of an insight on kind of what you're getting into. There are also other areas or other ways to get information out there that you might be able to utilize, such as I mentioned before, our complaints database. You can see if any complaints have been filed against a particular HOA, how many have been filed against an HOA, generally see how they've been resolved. The reason why we recommend that you kind of do this legwork ahead is that it's very important to do, because once you are in an HOA, you're subject to its authority. You are responsible to comply with their adopted rules and regulations. Once you're in, you're in. It doesn't matter if you weren't there when they were adopted. You're bound by them as long as they are appropriately in effect. So it's really important to be prepared beforehand and kind of know what you're getting into before you commit. So as I've stated before, under this act, the enforcement mechanism is court. So magistrate's court does have some jurisdiction regarding HOA issues if the amount in issue does not exceed $7,500. Also, as I mentioned a couple times, there is complaint process and reporting requirements for our department. Under this act, we are to take and collect specific data on HOA complaints and compile and share this data with the governor and the General Assembly each year. Before the act, our department regularly received HOA complaints like we receive complaints any other type of business. What the law changed was now we take and collect that data and we pass it on to the governor and the General Assembly each year. That allows them the opportunity to see any trends in the HOA space that may be occurring in the state that may require a law change or clarification. The law is very clear that our department does not have much authority over homeowners association as far as the complaints process and things of that nature. As I said, we can attempt to help through voluntary mediation, but that's kind of the extent of our ability when it comes to HOA issues. I'll also say at this point that if a consumer does need to file an HOA complaint, there is a specific supplemental form that needs to be included with the complaint. That supplemental form is the data that we report each year. So if we do not have that supplemental form completed with the complaint, we're going to be unable to process that complaint. So being that we do not have a whole lot of regulatory or enforcement authority in this area, we do kind of have a bit of a screening process for HOA complaints. If we receive a complaint and it appears that it's more of a personal issue regarding an HOA and not it's not a situation that doesn't involve a particular covenant or a bylaw or any kind of unfair implementation of the rules, we may recommend at the outset prior to our mediation process that you speak with a private attorney, because they would probably be able to assist you greater than we might be able to. But we are certainly here to accept complaints and mediate when we can. And that's kind of what my next slide explains, is what role do we play under this act. Again, we receive the complaints, we collect the HOA complaint data, we share the data with the governor and the General Assembly, and we do what we're doing today, and provide education to homeowners and homeowners associations about the Homeowners Association Act. And as I've already stated, what we do not do is administer the act or enforce the act. The act specifically says, for instance, that our department does not have the authority to arbitrate HOA complaints. So we're not able to force an HOA to provide a particular resolution to a complaint. But even so, we still recommend that you do file a complaint with consumer.sc.gov or with us at our website, consumer.sc.gov. Because it's useful information that we compile in our annual report. And we have had success in the past through our voluntary mediation with assisting consumers on their HOA issues, whether it might be access to documents or just a certain issue that maybe the HOA was unaware was even occurring. So that's kind of a very broad overview of the Homeowners Association Act. So let's look at some scenarios and kind of see how this act works to certain general situations that we typically hear about from consumers. So scenario one, if the bylaws and the covenants on file are older than 2018, are they still valid? Under this act, the answer is yes, provided that they were recorded prior to the effective date of the Homeowners Association law, which again was May 17th, 2018. If they were recorded where they need to be recorded, they are effective. Also, any amendments to these governing documents must be filed by January 10th, the year following their adoption. So this, of course, includes things like the master deeds, the declarations, and the bylaws, and any amendments to them. Scenario two, what about the rules and regulations? If they're amended, when can they be enforced and put into practice? The answer is that they are effective when they are passed or adopted by your HOA in whichever way that their documents prescribe that rules and regulations are passed and adopted. However, these amendments to the rules and regulations must be filed by January 10th of the year following their adoption in order to remain effective and enforceable. So that covers the South Carolina Homeowners Association Act. And now I'm going to go into the South Carolina Nonprofit Corporation Act, which also covers certain homeowners associations that have registered as nonprofit. Now, one thing you may have noticed about the previous act that I talked about is that there is no filing requirement at the state level for a homeowners association to let an agency or department know that they've been created or that they exist. The only thing that they need to do is file their governing documents with the appropriate agency, depending on which county they are in. However, if a homeowners association chooses to become a nonprofit corporation, they do have a reporting requirement to the South Carolina Secretary of State. They must file their nonprofit articles of incorporation with the Secretary of State. And if you are wondering whether or not your particular HOA has been filed as a nonprofit corporation, you can search this. You can search Secretary of State's business entity searchings or business entities search at businessfilings.sc.gov. Type in your HOA's name there, and it should pull it up if it is a nonprofit. Now, I did kind of mention earlier that per the Homeowners Association Act, the previous statute that I was just talking about, there are certain provisions of this act, the Nonprofit Corporation Act, that could apply to HOAs that even are not registered as nonprofits. And I'll point that out in a minute. So under the Nonprofit Corporation Act, a nonprofit is required to have directors and officers. They must have either a board of directors or someone named in the articles who has powers normally held by a board. This board, if there is a board, must be made up of 3 or more people elected by members or appointed through their bylaws. The term of these 3 positions are 5 years or less. And unless otherwise provided in the articles or the bylaws, a corporation must have a president, a secretary, and a treasurer. And one of these officers must take minutes at directors and members meetings. So as you can see, this statute is a little bit more detailed in what it requires from HOAs as opposed to the previous homeowner or the Homeowners Association Act that I discussed previously. There are also requirements under this act for how someone becomes a member of the corporation. That needs to be set out in the articles of incorporation or the bylaws. And unless the act says otherwise, or the articles or the bylaws say otherwise, each member of the nonprofit corporation is entitled to 1 vote. A quorum is defined as 10% of votes entitled to be cast, and proxies are allowed. Now, this statute also does require access to documents for members. It requires access to many more documents than the HOA Act that I discussed earlier, which was members lists and budget. But for nonprofit corporations, members should have access to documents for minutes of directors and members meetings, including committees of the board, articles and any current amendments, names and addresses of its current directors and officers, written communications to members made within the past 3 years, including financial statements, records of all actions approved by members for the past 3 years, and copies of any reports filed with the Secretary of State, which, if they're a nonprofit, they usually have annual reporting requirements with the Secretary of State. They also must provide notice for different kinds of meetings, more so than what the Homeowners Association Act requires, which was notice for meetings for raising the annual budget. Under this act, there are more notice requirements. So nonprofit corporations must have an annual meeting each year where the president and CFO report on activities and the financial conditions of the corporation. That meeting notice that's given to members must be, under the statute, fair and reasonable. So to be fair and reasonable, The notice must have the place, date, and time of each annual, regular, and special meeting, and that notice must be given at least 10 days ahead of time, but no sooner than 60 days before the meeting. And that notice must include any matter the members must approve. If it's an annual or regular meeting, or if it's a specially called meeting, it must provide a description of what will be discussed during that meeting. And this notice must also include a description of any issues a member intends to raise at the meeting, so long as certain requirements are met. So for a meeting notice to be fair and reasonable, these boxes must be checked, and the notice must be given within that 50-day window, that 10 days ahead of time, but no sooner than 60 days before the meeting. The law also says that this notice must be sent by first class or registered mail, so it's not good enough for a nonprofit corporation to post it in a common area or put it on their website. It must be mailed to members. So let's look at another example of how the South Carolina Nonprofit Corporation Act works. So in this scenario, an HOA member is asking for access to meeting minutes from 5 years ago. Does the nonprofit HOA have to provide these records? Under this act, if the corporation is a nonprofit, then yes, they do, because an HOA must comply with the Nonprofit Corporation Act in its entirety, and Section 1601 of the Act requires that a nonprofit corporation keeps their minutes in perpetuity, and 1602 requires records to be open for inspection upon written demand or notice of a member. But if the HOA is a nonprofit, the answer is maybe, because there's less restrictions on HOAs that are not nonprofit corporations. So in that scenario, it depends on what the HOA's bylaws say about their record maintenance and retention of documents. But especially with reference to the nonprofit corporation HOAs, if they're, for some reason, that HOA is not complying with a valid request for records, then again, the Act allows a homeowner to go to circuit court for enforcement. That is the enforcement mechanism of this statute. So another scenario, an HOA member is asking for access to invoices. Does the Homeowners Association have to provide them? Again, if it's a nonprofit, yes, for similar reasons from scenario one. HOA has to comply with the Nonprofit Corporation Act in its entirety if it's a nonprofit corporation. 1601 requires appropriate accounting records be maintained, and 1602 requires these records be open for inspection upon written demand or notice of a member, including accounting records. And similarly to scenario one, if they are not a nonprofit, love double negatives, but if it is not a nonprofit, the answer is maybe, for the same reason. It would depend on what the HOA bylaws say about access to records. The reason why this is because, again, as far as records access for HOAs that are not a nonprofit, it only singles out access to budget and member lists. So it does not single out invoices be available. One popular question that we get from homeowners is, what about attorney invoices? Do nonprofits have to, or not, do HOAs have to provide access to attorney invoices for attorneys that are representing HOAs? And that's kind of where you throw all this out, and it's a bit of a gray area that honestly we here cannot answer. What we're hearing from HOAs about this issue is that it is their position that HOAs claim attorney-client privilege for attorney invoices, meaning that the HOAs are unable to provide them to third parties. Of course, you know, an attorney that specializes in HOA issues may have a different opinion. You know, whether or not you can have perhaps a redacted invoice be provided, or or kind of general details with monetary amounts be provided, things of that nature. Again, it's not something that we as a department can speak on. It's a very complex issue when it comes to attorney-client privilege. It's very dependent on fact patterns of individual situations. So if anyone has any questions about whether or not an HOA should provide attorney invoices, best we can recommend is that you speak to a private attorney about that, someone who is well versed in HOA laws. So for another scenario, in this instance, a consumer would like to contact a member of the board of the HOA. They've asked the HOA for the contact information of the board member, and the HOA has refused to provide the board member's contact information. Does the HOA have to provide this information to members? Under this act, if they are a nonprofit corporation, the answer is yes. For similar reasons as the previous two scenarios, they must comply with the Nonprofit Corporation Act in full. 1602 requires records be open for inspection upon written demand, and this includes a list of names and businesses or home addresses of its current directors or officers, which are required to be kept pursuant to Section 1601 of this act. If they are a nonprofit, well, the answer is still yes, and that's kind of, this is what I was kind of foreshadowing earlier, a situation where the Nonprofit Corporation Act can apply to HOAs that are not registered as nonprofit corporations. And the reason why a not nonprofit is required to produce this information is because the Homeowners Association Act requires all HOAs, nonprofit or not, comply with certain provisions of the Nonprofit Act. In this case, while it doesn't reference Section 1601 specifically, it does include references to 1602 and 1605 of the South Carolina Nonprofit Corporation Act. And what these are, 1605 limits the use of a member list, why a member can request member list. They can't use it for like solicitation purposes or things. They have to have a genuine HOA related reason to request those lists for the purposes of permitting access to budget and homeowners membership lists. So at the very least, the nonprofit corporation says that an HOA has to permit access to a members list. And in most scenarios, that likely has the board members' information on it. So that covers the South Carolina Nonprofit Corporation Act. As you can see, it has a few more, several more details about what an HOA must set up in writing and the things that they have to comply with. There is one more act, and that is the South Carolina Horizontal Property Act. And this one is probably the most detailed one as far as what is required by an association and how they are operating. So like the others, there is a filing requirement here, and a horizontal property regime must file, or lessees or owners must draft a master deed and lease stating that they want to create the regime. They must attach its bylaws, a plot plan, and a building plan, and they must record it with the Register of Deeds or Clerk of Court in the county where the property is located. So just on the outset, I probably should have said that these types of regimes, horizontal property regimes, they're usually set up in apartment complexes or condominiums. And as I said, these are some of the most the most detailed of the three acts for HOAs. But getting back to the master deed and lease, it must include a description of land and buildings, a general description and number of each apartment in the horizontal property regime, a description of common elements and restricted common elements, the value of the property, as well as each apartment's value, along with the percentage of rights to the common elements of the regime. The name of the regime must be recorded and must include horizontal property regime at the end. And the master deed and lease must provide a description of the legal rights and obligations of an apartment owner, the co-owners, and the person or people establishing the regime. And if this regime is being planned, or if the property is being developed in multiple stages, there are additional reporting requirements that are required. So these regimes must also file their bylaws, and these bylaws must include certain sections regarding the administration, how the regime is going to be run, whether that is an administrator or a board. It must outline the powers that each body has in their administration, the manner of removal of any administrator or board member, or any kind of compensation that those people are to receive. It must also outline the method of calling a meeting for owners, who will preside over those meetings and who will take minutes. As far as voting, the bylaws must state that a majority of at least 51% of members is required to adopt decisions. And as far as common elements and services, the bylaws must describe these common elements and services and must describe the care, upkeep, and surveillance plans of property and common area expenses. And they must provide a designation and dismissal of personnel necessary to provide common services. So how they are going to engage personnel in maintaining these common elements. The bylaws also must include a description of the manner of payments that members will make and how they will be collected from owners. Now, as far as expenses, record keeping, and access to records, owners must contribute a pro rata percentage toward the expenses of the administration, the maintenance and repair of common elements, the repair of limited common elements. For example, if insurance doesn't cover the repairs, or reconstruction of common elements that are shared by a few owners. Also, owners must, they're bound by any other item or service that they agree to. Any assessments that are left unpaid at the time an apartment sells will be taken out of that sale price. Also, another thing to point out is that a regime administrator has to keep detailed receipts as far as expenses go. They must keep detailed receipts and statements of expenditures, and the owners have a right to inspect those in a manner that's prescribed by the Act. So the Horizontal Property Act also outlines some general apartment owner property rights. An apartment owner has the right to exclusive ownership of their apartment, and they have the right to use common elements so long as the use does not hinder the rights of other owners. I've said common elements a few times now. What are these? Common elements are defined, well, they're not defined, but they include many different types of things, similar to apartment complexes. They include the elevators, garbage incinerators, basements, if you have roof access, the yard, gardens, pools, all sorts of things. They need to be outlined in the bylaws what the common areas are. There can also be limited common elements set up, which would be common elements that the owners collectively agree are reserved for the use of specific owners. And again, this is a broad overview of this act. There are other things that are required in as far as property rights, and there are parts that are covered, such as repairs, insuring the property, how in the future, if the regime needs to be dismantled, how that's done. So it definitely does go into more detail that I'm going to go into today. But as far as our scenarios go, say, for example, I live in a horizontal property regime. Is it true that when the unit above me has a water leak that damages my unit, that I am responsible to fix it via my insurance? The answer is a lawyer's favorite answer, which is that it depends. First, what it depends on is what the master deed or the lease says. Since the master deed and lease describes the full rights and obligations of an apartment owner, co-owners, and person establishing the regime, and it provides a description of the general common elements and any limited common elements of the regime. It really depends on what those definitions are. Because like I said, general common elements can include a multitude of things, very different things depending on that particular regime. And it depends on the fact pattern. So for instance, is the leak occurring in one of the common elements? What's the cause of the leak otherwise? Is it caused by some essential service that's being provided to the property as a whole? The way that these regimes work basically is that both owners of the property, for lack of a better term, insure the property by way of the regime itself, but they also carry their own homeowners insurance. So that's a fact specific question, and it really depends on certain circumstances to a person's particular situation. And so there could be any answer really, and it could depend on what the master deed and lease say. It could be that insurance is set up by the regime to cover these things if that's so stated in the master deed or lease. So that's kind of the broad overview of the three laws that cover HOAs here in South Carolina. So what are some tips for dealing with HOA issues? First and foremost, if you're unhappy with the action of your association, the first thing you should try is to try talking with your HOA board of directors, and you want to come to them prepared. You want to make sure you're looking at the governing documents beforehand, and you know the rules and regulations, you know the CC&Rs that your HOA has created. These documents may lay out a specific complaint process for homeowners that you want to be sure to follow to make sure that you are following the rules of the HOA. If your particular HOA board of directors is not too receptive and you're still not happy with the issue, of course, being a member, you can elect other members that you think will be more responsive to your needs, or you can seek election yourself. These HOAs, they're creatures of their own creation, so it's, you know, you can work within the system that they've created for themselves, and hopefully that can get some issues resolved. But if that does not work, the enforcement mechanism for these acts is it's court, so mostly magistrate's court or possibly circuit court. But if the issue does involve a monetary dispute that's under $7,500, a homeowner can take the issue up with magistrate's court. Now, I'll always recommend that you speak to an attorney when it comes to any legal issue. However, an attorney does not need to represent you at magistrate's court. And the Supreme Court of South Carolina has provided some FAQs, some self-help FAQs at this link that's here on this slide that might be able to assist in walking someone who is not represented by an attorney kind of through the procedural process of magistrate's court. As I've stated, if you're still unhappy and you're not going the magistrate's court route, you can talk to a attorney who is well versed in HOA laws. If you look at the number here in the website, this is the South Carolina Bar's lawyer referral service. They may be able to connect you with one or more attorneys who are knowledgeable in HOA laws, and they have agreed to initial consultation meetings with clients for reduced rates. So you can certainly kind of see what's out there as far as attorneys who may be able to assist you. Of course, you can file a complaint with our department if you're still unhappy and you don't want to go the court route. We do have our voluntary mediation services that we do have success with regarding HOA issues. But it's also important to file a complaint with us, as I've been saying, because we are required to report HOA data to the governor and the General Assembly every year. This will get your issue on record, and it will be reported to the governor and the General Assembly at the end of the year. Of course, lastly, if you think this is a situation that you may have with an HOA that's not adequately covered by the laws that are in effect as are, contact your legislature or your legislators directly. Let them know where you think the HOA laws can be improved. If there's any other additions or subtractions that may need to be made. You can contact your legislator at the State House's website, which is scstatehouse.gov. I point this out because if you look at the bottom left bracket there, you can punch in your address and you can see who represents you in the Senate and the House of Representatives, and that will provide contact information. While you're at this website, you can also see proposed bills of possible laws that may be adopted in the future regarding homeowners associations. You can search by keyword. So if you would search by homeowners association, you could pull up a certain legislation that is that has been introduced as a bill. Again, it has not yet been adopted as law, but for this legislative period, for this legislative session, these are the bills regarding HOAs that are with the House of Representatives right now. So again, I'll say it, I think, a fourth time today. That's important to remember that these are bills. At the time of this presentation, none of them have been adopted as law by the legislature, so they have no legal enforceability or authority. It's possible that none or all may pass. I have no way of knowing. I can't tell you one way or the other how they're going to go. But these are the bills that have been adopted, or not adopted, I'm sorry. These are the bills that have been introduced in the House of Representatives for this legislative session. And as you can see, they cover various issues for HOAs. The first one there, House Bill 3090, proposes to enact the revised Uniform Unincorporated Nonprofit Association Act. Basically what that is, it's a model set of laws that 17 other states have adopted in whole or in part. It establishes that a nonprofit association is a legal entity that is distinct from its members and managers. And what that would do, it affords the nonprofit association the same powers that an individual would have to do all things necessary or convenient to carry out their purpose. So it kind of relaxes some of the requirements on a nonprofit corporation in the exercise of their powers. That one's currently referred to the Committee on Judiciary. House Bill 3180, if adopted into law, it would prohibit an HOA's authority to foreclose property to collect unpaid dues, fees, or fines. That one's with the Committee of Labor, Commerce, and Industry. 3258 would allow homeowners or tenants to display political signs, and it would also allow HOAs to establish some certain ground rules for displaying those kinds of signs. That's currently with the Committee on Judiciary. 3259 would require an HOA to send copies of the annual operating budget and operating expenses to homeowners, and also submit those here to our department, South Carolina Department of Consumer Affairs. 3568 would require HOAs. It would kind of beef up that 48-hour notice requirement in the HOA Act. It would require that before spending funds not within the approved budget, that the HOA provide 48-hour notice of a special meeting, and a quorum would have to be present to approve that expenditure. That's currently with the Committee on Labor, Commerce, and Industry. 3775 would say that HOAs cannot restrict homeowners from flying an American flag on a designated flagpole on their property. Now, there's, on the Senate side of things, there's not as many bills floating out there. Senate Bill 118 would require HOAs to provide a statement of unpaid assessments or other charges to the homeowner upon request. Senate Bill 421, if adopted, would say that HOAs cannot prohibit homeowners from peacefully assembling or organizing speaking events, canvassing or circulating materials on the property or within the HOA's territory. And Senate Bill 422 would prohibit HOAs from prohibiting the installation of solar panels that cannot be seen from the street or common areas surrounding a residence. So I'll say it a fifth time. It's important to note these are not laws in effect at this time, and one or multiple or none could become laws in the future. But this is that's kind of what's on the dashboard of the legislature right now regarding HOAs. If you want to follow these bills and kind of see where they are in the legislative process, again, you go to the State House's website. You can punch in that specific bill in that search area on the right side of the screen that I showed you right here on the right side, and you can follow the legislative process there. So, what kind of resources does our department have for homeowners regarding HOAs? Well, if you go to our website, as I said a few times now, you can file a complaint, and we would like you to file that complaint so we can have the information that we need to report to the governor and the General Assembly. If you click on that, file a complaint, in the center of the home screen there, you'll be brought to this page, and you will see that there is a specific link for HOA complaints. If you were to click on that, you will see that there are two ways to file your complaint, either through our online complaints portal. If you set up an online account in our complaints portal, you can file a complaint that way, or you can print out the necessary documents and send them back to us, and we'll get those processed as complaints. We also have an abundance of educational material for homeowners on our website. If you go and hit the Consumer Resources tab at the top of our website and Help for Homeowners, you will see that we have a whole bunch of different documents created, a whole bunch of publications regarding HOAs. We specifically have outlines and FAQs for the laws that I have discussed today. May go into a little bit more detail than I did today. We also have links for the laws themselves. If you want to get more granular in reviewing the HOA laws, you can do that from our website. We also have all the contacts you may need to contact regarding your particular HOA issue, as you can see there. Pretty much every contact that I've mentioned in this presentation. And you can also access the Homeowners Association report that we create each year. And you can review the information that is published there. So that about covers my presentation here, or at least the substance of it. Looks like we are right at an hour now, or just a minute past, but if anyone has any questions, I will certainly try and get through them. But again, if you do have a very specific issue that I really cannot go into detail on, you might need to speak to a private attorney.
Hey, Zach, it's Bailey here. So we've had a number of questions that I've been able to answer privately, but there are some that I think are good to kind of go over, because we got a number of questions specifically about that membership list. So people are concerned about, and this came in 5 times during the presentation, asking about, does that membership list really need to be shared? And I know you answered this, but I figured it could probably just be reiterated again, that it obviously depends on what applies to your HOA, but in the Nonprofit Corporation Act and in the HOA Act, there are sections in there that do require a membership list to be shared if the requester is requesting it for appropriate use. So just to let people know that, and I understand why that question's being asked. I mean, we talk about scams all the time, and we talk about people protecting their information, but it is a portion in both of those acts that a membership list does need to be provided for an appropriate purpose. So I just wanted to reiterate that, because that was brought up multiple times. Here are some questions that I wasn't particularly able to answer. Are copies of checks and bank statements also included in nonprofit financial disclosures to homeowners? Do you know that, Zach?
I do not believe that the act goes into that much detail about the kind of financial documents that must be produced. I can look it up and see, but I don't think the act goes into that kind of detail about what specific.
Yeah, I don't think it does either, but we can definitely get back to this consumer and let them know if the Nonprofit Corporation Act has any specifics about financial disclosures.
Mhm.
This is a really good question. I like this question. If you purchased your home and there was no HOA when you purchased the home, but after, a certain amount of years or so, an HOA is developed and voted on, are you bound to the rules of that HOA?
Yes, if it is for if it is set up for the surrounding property in that property area, I believe you are bound by the HOA as long as it's been adopted, as long as it's been created properly.
Okay. A lot more questions are coming in now that we've gotten to the end here. So, more questions about the membership list of like what's included in the membership list. I think, I don't know if you know off the top of your head, Zach, but I'm pretty sure that would be dependent on the CCRCs of the actual HOA, but usually it's the name and the address and the phone number, potentially the email of the consumer within the HOA.
Yeah, that would probably be defined by the bylaws.
Yeah.
The statute itself it says member lists.
Yeah, it doesn't. Yeah, the laws, both, I actually looked it up, both the HOA Act and the Nonprofit Corporation Act do not define what a membership list actually has on it. So I think it would be dependent on your bylaws. Question, how many HOA meetings are required annually?
Well, under the Nonprofit Corporation Act, I believe it's just the annual meeting.
Yeah, so I think it's dependent on the act.
Yeah, and that number could increase depending on what the issues are at hand that they need to have meetings on. But all details omitted. The bare basic requirement under the Nonprofit Corporation Act is one meeting, an annual meeting to go over the kind of the financial situation of the nonprofit corporation. As far as the HOA Act goes, and as far as the HOA Act goes, the number of meetings is set up by the governing documents. And okay. I'm sorry, off the top of my head, I can't remember if the Horizontal Property Regime Act covered how many meetings are required. But again, that's something that I believe even under that act would be established by the bylaws.
Can somebody see the tax returns of an HOA if they are a nonprofit?
If they are a nonprofit, that's a good question. I'm sorry, I'm not sure.
Yeah, we'll get back to you on that one. We can look that up and see, and we'll get back to you.
Mm-hmm.
This is a good question that I can actually answer. So somebody says that they bought a condo, and they weren't made aware that it was an HOA, but it was a COA. So a COA is just another term for an HOA. So if you were made aware, so a COA is a condo owners association. That's just another term for a homeowners association. They can be used interchangeably. Because you live in a condo, most likely the Horizontal Property Regime Act, not always, but the Horizontal Property Regime Act could apply there, or all three acts could apply technically. But if you were made aware that you were moving into a COA, then that still is being made aware that you were in an HOA. They can be used interchangeably though. Somebody asked a question, if master deeds haven't been updated in years, this person specifically said 2007, are those master deeds technically still legal?
Well, it depends. If it's not a nonprofit corporation, then they would have had to have been adopted by May 2018. They would have had to have been not adopted, I'm sorry, recorded in the appropriate office. So, depending on the county that the HOA is organized in, it could be the clerk of court, register of mean conveyance, or register of deeds. That it varies by county. But if they existed prior to May, I had it on the slide, I can't remember the exact date, but it was May 2018. They had to be recorded by January 10th, 2019 in order to remain in effect. And any amendments to those governing documents or bylaws or rules, amendments, whatever, they can be adopted according to an HOA's bylaws. However, whatever process they have defined to adopt amendments or new documents, any changes, they go into effect upon that adoption. However, they also must be recorded in the appropriate place by January 10th the following year of its adoption.
Yeah, and that might answer the question that somebody just asked of if an HOA creates an addendum or has an addendum.
Remember the distinction, that's for nonprofit HOA, or I'm sorry, that's for not nonprofit HOAs. The best way to describe it in my mind is in that double negative, so I apologize for that.
So this question is, if an HOA creates an addendum and it's not filed in court, is it valid? I think that's probably an it depends also.
Again, not court, the appropriate office.
The appropriate, yeah.
Yeah, register of deeds or register of mean conveyance or clerk of court. It could be court, depending. It could be clerk of court depending on the county.
There's a lot of questions here that we're probably going to have to follow up on specific situations. Can a board and HOA create bylaws without taking votes of the homeowners?
That's again, it depends on whether or not it's a nonprofit corporation or a not nonprofit corporation. If it's not a nonprofit, it depends on the bylaws. They set up the voting process. If it is a nonprofit, there are certain minimum requirements that are required for voting. But that act also allows certain amendments to that process be outlined in that nonprofit corporation's bylaws. And the horizontal property regime is a bit more relaxed on that. It just says 51% of votes are needed. That answer the question?
Yes, I think so. Yeah, I think so.
Yeah, it's a bit of a all these answers really depend on what kind of HOA it is, and even then, in most scenarios, still the answer is, what do the bylaws say, or what do the governing documents say?
So somebody is saying they don't understand that if they're a nonprofit, if an addendum is not filed in the register of deeds, is it enforceable? So they're saying that an addendum was done, but they didn't file it in the register of deeds. Is that enforceable?
That's probably one that we'll have to follow up on.
Yeah.
I don't want to give a wrong answer on that. But yeah, we can certainly look into that here.
So again, there's a lot of questions that are coming in that are specific situations. And I just want to let you know, we are 15 minutes over here almost. If you have to leave, you can. If you've asked a question, I will follow up with you for sure. I'm going through, there's a lot of questions here I'm trying to sift through to see if there's any general ones that might be good for the group before we end. So here's one about nonprofit HOAs requiring voting, and maybe we can answer this one, Zach. If a nonprofit HOA has it in their covenants and bylaws that it's required 2/3 of voting members to amend the covenants and bylaws, does that mean that 2/3 of the total members, like of the whole HOA, have to vote, or just 2/3 of the total members at the meeting?
I think that would need to be clarified in the bylaws. That would probably have to be clarified in the bylaws, because the Nonprofit Corporation Act pretty much says that if the voting process, the requirements for voting that the Nonprofit Corporation Act establishes are basically kind of like the floor voting requirements, and they specifically say that the corporations can make their voting rules by, in their bylaws as well. So I think as far as nonprofits go, the 10% quorum and things like that, that's kind of like the floor. So yeah, I guess the answer, unfortunately, as it is to a lot of these questions, is it depends on what the bylaws say.
Okay. And then one of the questions is, will all of us be sent to follow-up questions? So if you had specific questions, I will follow up with you individually, but I'm not going to send all of the follow-up questions to each individual attendee, just because that will have consumer information in it. And then the last question I think we can go over before we end here is, I just lost it. Scrolling, and then I lost it. Oh, it was about a question about management companies. So this person says that their community is comprised of an HOA board and an externally contracted management company. Are there any laws regarding complaints from the HOA board about the management company or about management companies in general? What I will say is, we, in our HOA report, which you can look at on our website, like Zach mentioned earlier, we do specify in that report whether the complaint is against a private HOA or an externally contracted management company. So you can see whether the complaint is against that type of company. And that would be who would deal with the complaint the majority of the time if there was a complaint against the management company. But correct me if I'm wrong, Zach, I don't believe there's any laws specific to management companies of HOAs currently on the books.
No, not that I'm aware of.
Okay. Okay, so, oh, and this is a really good last question. I know I just said the last one would be the last one, but this just came in, and I think this is a good one because I get this question a lot. If it's filed as a nonprofit and a horizontal property, does one supersede the other?
That is a very good question. I'm sorry, that's one I'd have to look into. I've never had that question myself, so.
Well, and I will say that you can have an HOA where all three laws apply, which is extremely confusing.
Yeah.
And we get that. We get that it's confusing that your HOA can be a part of the HOA Act, a nonprofit, and a horizontal property. So we'll look into that for you and get back to you on that. If there's anybody else who has questions on that, just email me, bparker@scconsumer.gov. I get that question all the time of which one would we follow, because the Horizontal Property Act is more specific. But I know we've gone way over time, so we're going to let you guys have your morning back. Thank you so much, Zach. And everybody stay safe and enjoy this lovely weather.
Yes,
bye.